I should let to mention I 74 of 2026. This may be listed along with the motion item number 13.
Along with
Connected this.
That item I'm appearing, that one IE was filed day before, and this IE was filed yesterday, and I received a copy. I'm just requesting the matter had been earlier listed on a Monday.
Okay.
Final hearing. I'm requesting my counsel appearing from Delhi to VC. So it may be kept on Monday. Both the IEs may be taken up. By then, I'll file my response also. Because
The similar matter, Your Worship, the IS 72 was filed day before yesterday,
Okay.
and the one I meant to mention was
I have-
filed yesterday.
It's okay for you. If
Let
it's
better come up.
Monday.
No, let the matter be called, and so we can take up together.
Okay, we'll take a call when the matter comes.
at 2, then your lordship, it was said at 2. I've communicated that it'll be after lunch at 2. My counsel will be appearing through VC then.
I mean, because I also have some time constraint today. Because anyway, so don't worry. Either if both of you, both the sides want
Let
it
the matter be
posted on Monday along with the main writ petition, then it's okay. I have no problem. But if you want the matter to be called out and taken up now, then that is also okay for us.
what I want is the matter to be listed together.
Okay, let's hold on.
Okay.
Please, for some time. Then we'll take a call after some time.
For motion from the supplementary cost list, item number 10.
After some time.
For motion from the supplementary cost list, item number 11.
Yes, Mr. Chairman.
May I please your lordship? This matter relates to election of village council members in near model village under Kohima district. On 13th of January, 13th of March, sorry. The deputy commissioner has issued a notification whereby all the village councils under Kohima districts have been dissolved and directed to conduct fresh elections for the tenure 2026 to 2031.
Okay.
And then the direction was to conduct the election in accordance with the provisions of the Nagaland Village and Area Council Act 1978, and also in accordance with the prevailing customary practice. That was the direction. Accordingly, the ADC of the concerned village, that is falling under Chobobuzo ADC, on 18th of March, he has issued the notification directing the village council to conduct the election in accordance with the provisions of the Act and also in terms of the customary practices. As per the direction, and to submit on or before 20th April 2026.
20th April.
Yes. So, and accordingly, the village council has summoned a meeting for the election and selection. When there is no contesting, then it will be selection as per the customary
Otherwise,
practices by way of raising hands, showing hands. So it was fixed on 25th of March for holding the fresh election. So election was held. There, since our custom is that the number of candidates will be there, read out, and then raise your hands. So if the majority agrees, then that is the one who is nominated for the village council election. So that is how it was done. And then the election, the 4 petitioners who are the petitioners here, they were selected on the day of the election by overwhelming majority. And then the election was forwarded to the administration, that is extra assistant commissioner and additional deputy commissioner. They are the administrative officers in the district, and then it was submitted. What happened on 22nd of April 2026, the HGB has lodged a complaint to the effect that election was not held in accordance with the customary practices
Hmm.
because one man, one vote was not exercised. He means to say that one man, one vote. There are 4 candidates. So, as per the custom, the candidates will be read out. So and so candidate.
Hmm.
If willing, I should raise hand.
Hmm.
Second candidate,
Again,
I should raise hand.
same. process.
So 4 times I have to raise hand.
Mhm.
That was objected
Mhm.
on the ground that one person can vote only once, while one should raise 4 times.
Oh.
But when there are more than one candidate,
Hmm.
there is no power to raise on each candidate. I can raise even 10 times if there are 10 candidates.
Okay.
So that's how the election was conducted. What happened on 22nd of April,
Mhm.
the GB has lodged a complaint to the ADC. On the same day,
Mhm.
the DC has ordered for the fresh election again.
First election.
Now, in order to order for a fresh election, at least if there is a complaint that election was not held in accordance with the custom, is it not the bounden duty of the administration, either ADC or DC, to go to the village and then verify and inquire
Make an
in what manner, what customary law was followed, how it was done? At least they should have the minimum courtesy to verify that. Without doing that, just complaint has been lodged as if they have been waiting for that to receive. He has suddenly issued for conducting a fresh election, and accordingly, election was held in terms of the direction of the additional deputy commissioner, which Lordship will find at page 51. That is the letter of the ADC, directing the village council to select the village council members afresh. If you want to do that, first, you cancel the earlier election and nullify that. No. Now we have 2 elections. Which one to take? So
New
the
election has been directed. New election has been directed.
conducted on 24.
Already conducted also.
Yes, already conducted.
Oh.
So I'm praying for that election conducted, but no appointment should be made on the basis of the second election.
Second election is already conducted on 24th.
Yes.
But, okay. The
No
effect-
appointment order has been issued till the filing of this writ petition, Lordship. So at this stage, notice may be issued. Let them say whatever they want to say, but no appointment should be issued on the basis of the subsequent election, Lordship. That is in terms of the letter to the 22nd April 2026.
you have accepted notice on behalf of respondent number
1 to 5, your lordship.
1 to 5. Okay. The others are private respondents.
Others are private.
Yes. I will take steps by speed post as well as the dusty service also to expedite the matter.
Third, learned senior counsel CT Jam for the petition
I am assisted by Aliba Uzakam.
and the senior government advocate,
Senior government advocate. No, I'm changed.
senior government advocate for who's appearing on behalf of respondent number 1 to 5. The instant writ petition has been filed by the petitioners, agreed by the order dated, which is the impugn order now.
22/4/2026.
2026 passed by the learned additional
Additional Deputy Commissioner.
Deputy Commissioner Kohima with regard to election to the village council of village.
Near Hay Model Village. On the top, Lordship will find below the HGV.
Mhm.
Near Hay Model Village, page 51.
Yes, near Hay Model Village. It is contended by the learned senior council that an election, the white order dated, white notification dated, so the learned deputy commissioner of Kohima directed all the villages to have fresh elections
Yes.
for the village council members. And the date of the election was fixed on
25/3/2026.
25/3/2026. And accordingly, the election was held wherein wherein
Four petitioners. Four petitioners.
4 rounds of voting.
Yes.
There was 6 petitioners, right? 4 rounds.
Yes.
4
There
rounds,
were 6 candidates and
6
four
rounds of voting.
requirement is 4 members only, 4 posts.
Okay.
So out of 6, 4 were selected
Okay.
by majority.
In which there were 6 candidates and 4 candidates. The four candidates were selected for the 4 posts of members by voice vote, voice vote or hand,
Yes.
hand vote, full stop,
By raising hands.
by raising hands. As there were 4 posts, therefore such an exercise was done in 4 rounds, full stop. The petitioners have been selected as the village council members in the said process. Subsequently, based on a complaint made by the head GB of the village, the learned additional deputy commissioner, the office of the learned deputy commissioner Kohima, through the learned additional deputy commissioner, without making any inquiry, cancelled the said election and
Election was not cancelled, but directed for a fresh election again.
Okay.
Without cancelling the earlier election.
the election council cancelling the election on
Item 15 solution, two commissions.
directed fresh election, and subsequently that was also held on 24/4/2026, and 4 members were selected. 4 members.
No, not 4 members, only 2 members were selected.
Anyway, we need not write that.
I don't know in what
Not sure.
manner they can
24/4/2026.
do that.
The learned senior counsel submits that at this stage, while notice may be issued, he's seeking, he's praying that in the interim, no any appointment should be made pursuant to the second election held on 24/4/2026, and that the same was held without cancelling the earlier election, which was held on 25/3/2026. Issue note extra copies of the writ petition along with documents may be furnished to the learned senior government for the state respondents. Full stop. Further, steps of notice by speed post as well as dusting may be taken upon the respond number 629.
Yes.
629 within bracket private respondents. Compliance affidavit may be filed. Full stop. I have given my consideration to the prayer for interim order and peruse the relevant documents. Till the returnable date, the respondent authorities shall not give effect to the election dated, give effect to any appointments vis-a-vis the election, subsequent election dated 24/4/2026. Okay. Then examine the matter. Any records have to be?
No, no. Highly obliged.
May I please, your lordship?
Yes.
My lord, I am in VC, my lord. My lord, I am in VC, my lord. Item number 10, my lord, this, my lord, my item, my lord, this, due to, my lord, some difficulties, my lord.
Wait,
Could not-
I'll come to you. Don't worry.
My lord, I have one, the urgent matter in the principal bench also. If lordship allow my lord, this small,
Wait. I will accommodate. You attend that matter then and join after some time.
My lord, I'll be calling now.
Okay.
For motion, item number 10.
may I please, your lordship?
Okay. You are for item 10.
Yes, my item, the demotion matter.
I see.
The one my colleague is there, she will hand over one documents, my lord. Item number 10, my lord, is the order which was, my lord, reviewed, my lord. This, my lord, yes, my lord.
The review petition was dismissed, right?
Review petition was allowed, my lord.
It was allowed.
Yes, my lord. There is on the ground, my lord, there is, my lord, the cause of objection arise, my lord. But it was not, my lord, this, my lord, this, there is no ground, my lord. My lord, my friend, my lord, to hand over the main, the arbitration petition which was dismissed, my lord. Dismissed, my lord, this, my lord, it was dismissed on 1/11/2024, my lord. It was, they not enclosed, so, my lord, we are also, it was missed, my lord, this or judgment, my lord.
It has arisen out of
My lord, this,
arbitration matter.
my lord,
It has arisen out of an arbitration matter.
Yes, my lord. Arbitration, my lord. Section 34 application, my lord. It was dismissed by this initial the arbitration petition 34 petition, my lord.
Why-
So, my lord, this last paragraph, my lord, 4, my lord, paragraph 4 of the order, my lord.
Okay.
Paragraph 4 of the order, my lord. I have heard Anil Kamai, learned counsel for the petition. Lordship got it, or Lordship got it?
Yes, I'm on that. We are on the same page. Please proceed.
Yes, madam. And SK Medi learned CGC for the respondent. I've also produced the materials on the record. Coming to the point of limitation, it is seen that arbitral award was passed on 15/5/2023, and instant application for the setting aside of arbitral was filed on 4/12/2023. As per section 34(3) of the Act, the period of limitation is 90 days, and it provides provided further 30 days if the court satisfied that the applicant was prevented by sufficient cause for not making the application within 90 days. Noted above, the arbitral award was passed on 15/5/2023, and so the instant applicant should have been filed within 90 days, that is by 13/8/2023. As the proviso provided additional grace period 30 days for reason stated in hereby 12/9/2023. However, instant application is filed 4/12/2023, which is away beyond the period of limitation provided by the Act. As such, the instant application is filed beyond the period of limitation, and court has no jurisdiction to entertain the instant application. Accordingly, in view of the aforesaid, instant application is barred for limitation, and same here is hereby dismissed. This order was reviewed, my lord. This order is reviewed, my lord. The applicant filed a review, the application for review, my lord. This is in my petition, my lord.
Okay.
Petition, my lord.
Impugn order at page.
My lord.
Let us go to the impugn order, whereby
impugn order. Yes, my lord. Impugn order is, my lord. The impugn order is, my lord. The relevant portion is it starts from, my lord, page 22, my lord. The impugn order, my lord. Okay. And relevant page is, my lord, page 27, my lord. Page 27.
Just I'm coming.
Yes, ma'am. On the other aspect, learned counsel for the petitioner submitted the awarded amount. The award amount was deposited on 2/12/2023. And the petitioner has refused to accept the award deposited by the respondent on 13/11/2003. Hence, the cause of action still subsists and is a continuing one. And regards, it may be observed that once the petition under section 33(4), the act is disposed of either by the correction or rejection, the award becomes final here, unless set aside by the court. Further, this court also, the opinion, the refusal of the petitioner to accept the award deposited by the respondent cannot reset the clock for computing the period of limitation. Be as it may, in the instant case, the petitioner claimed that the petitioner under section 33(4) of the Act is pending disposal. Whereas the respondent claimed the said petition has already been rejected by letter 22 July 2023. However, the respondent has failed to show to when the said rejection letter in respect of section 33(4) of the Act was communicated to the petitioner. Therefore, in circumstances, upon assuming the petitioner learned about the rejection of the petition under section 33(4) of the Act of the date of deposit of the award amount of 2/12/2023, then the instant petition is within the limitation period, and the court is the considered opinion that it is justified to assume just the last cause of action arose on 2/11/2023 when the award was deposited. Hence, in view of the, it is considered the opinion to allow the review petition on conclusion that the petition is filed within the limitation period. My lord, this order was passed, my lord. This is not the ground. If they file a appeal before the High Court, my lord, under section 37, that is different. But they filed the review petition, my lord. And so, her review petition is concerned, my lord. Your lordship may turn the review petition, my lord. This page 10, my lord, page 10, paragraph 3, my lord. These are the grounds, my lord. The grounds for review and re-examination points are given, my lord. my lord, the honorable court, my lord, re-examined the entire case, my lord, and thereafter passed this cause of action come this. There is no ground, my lord, for the delay, my lord. The delay which was dismissed, my lord. There is no new facts, my lord. There is no error apparent of law, my lord, and in the order, my lord. And everything is it is not a ground for review the case, my lord. The lordship may produce the grounds, my lord. Grounds A, they violate the provision of the law. This is already, my lord, before the honorable court, my lord. B, the separate arbitrary appointed arbitrator. This is also considered in the order, my lord. The review petitioner raised objection challenging the arbitrator. This is also, my lord, considered, my lord. The objection and complaints has sole arbiter instead of sole arbiter. This is also considered. The arbiter award is illegal. This is also considered, my lord. Payment of arbitrator is done unilaterally. This is also reflected in the order, my lord. The amount was not received. This is also, my lord, dear my lord. So, my lord, the ground for review, my lord, whatever the whatever the provision says, my lord, provision says, my lord, how review lies, my lord. Review lies, my lord, only, my lord, this your lordship is aware. My lord, this the my lord.
Okay, so where was this order? It's now 50.
So my prayer, my lord, is that this is the learned court below wrongly passed this order, my lord. So my humble submission before this honorable court, my lord, notice may be issued, my lord, and the till returnable date, my lord, this the order passed by the learned court below may be stayed, my lord. Because there is no matter discovery of new and important matters of evidence which and after excessive due diligence was not within the knowledge, my lord, and could not be produced by them. But these are there is no such ground, my lord. Only, my lord, is the cause of action. So far, my lord, the Arbitration Act is concerned. So far, arbitration is clause is concerned. Section 34, my lord. Section 34(3). The application for setting aside may not be made after 3 months elapsed from the date on which the party making application and had received the award. And if a request has been made under Section 33 from the date on which the request has been disposed of. So this has been already disposed of, my lord. It was informed, my lord, it is July itself. This is also in our my lord, objection, my lord, objection file, my lord. Objection is enclosed here, my lord. Objection is also and it starts from, my lord, page 15 itself, my lord.
I've understood. Okay, will issue. I'll see. Heard Mr. S.K. Miri, learned CGS for the petitioner. The instant civil revision has been filed, agreed by the order dated order dated 30th January 2026,
Yes,
passed by the learned Principal District Judge Dimapur, Nagaland, in IA Civil number 49 of 2024, which was preferred by the respondents in disposed of arbitration case number 4 of 2023. The said arbitration case arose out of an application filed by the respondents under Section 34 of the Arbitration and Conciliation Act 1996, within bracket hereinafter the Act, seeking setting aside of the arbitral award dated 15/5/2023. However, the learned court below held that the application under Section 34 of the Act filed on 4/12/2023 was barred by the limitation period provided in Section 34(3) of the Act, which is 90 days and another 30 days upon showing cause to the court. The said period is to be counted from the date of receipt of the arbitral award by the party, or in case of a request, in case of a request made under, just reflect that language. No? Or if a request has been made under section 33, from the date on which request has been disposed of by the arbitral tribunal. The learned counsel, Mr. Mehdi, learned CGS, submits that by the impugn order, the learned court below allowed the review petition by traveling beyond the scope of the well-settled law regarding the scope of review jurisdiction. Full stop. It is contended and submitted that the learned review court entered into the merits of the matter and passed the impugn order in violation of the settled principles. Full stop. Issue notice upon the respondents. Steps may be taken by speed post. The petitioner is also at liberty to take parallel steps by dusty, in which case compliance affidavit shall be filed. Upon considering the matter at hand and perusing the relevant orders till the returnable date, the impugn order dated impugn order dated 30/1/2026 passed by the learned court bill shall remain stale.
My lord, suspended the proceeding, my lord, the proceeding of arbitration, my lord.
No, this will what this do? This will do, I think. The review petition, it is because the arbitration it was disposed of. The arbitration is disposed of. The arbitration was challenged. Arbitration was disposed of. Award was challenged. It was dismissed. Now review has been allowed. That means the award revives. So if I stay, I think that will do. I think that will do.
Subsequent, my lord, because next date is on 8, my lord, 8 of this month, my lord, next date, my lord.
For what?
Next,
in the
May, my lord, for hearing, my lord, the main case, my lord. 34. In this regard, some observation may be made, my lord.
The impugn order shall remain stale till the returnable date, and further proceedings in the arbitration case.
4 of 23, my lord.
Arbitration case may also be kept in abeyance for the moment till the returnable date.
Okay. Next date, my lord. After 4 weeks.
I've made the observation.
Yes, my lord. Next date is given, my lord.
Till the returnable date, that means the date given by this court.
Okay. Yes, my lord.
Cover the court date
yes,
of the learned court below. This is the matter. This is the matter after 3 weeks.
4 weeks, my lord. 4 weeks.
Well, let it be 3 weeks. Okay.
Yes, highly
3 weeks.
Highly
date to be fixed by.
For admission, item number 1.
Yes.
May I proceed, Your Honor? My lord, I am N. Kasumi. I am for the petition. This petition has been pending for the last 1 year.
Okay.
Already 12 adjournment has been granted to the respondents, but they failed to file reply affidavit. Now, even in CBC, 120 days is the maximum period for adjournment. Now, it's more than 1 year. And as per section 114G of the Evidence Act, no 136 BSA. If document is to be produced, and if it is not produced, then adverse inference is drawn against the respondents. So no time should be granted to the respondent for further adjournment. Now, this should be admitted because here in this present case, there is no disputed fact at all, my lord. It's only a question of law and vacuum of law. For example, let me cite one example.
It is regarding the acquisition of land
Land acquisitions by
without following procedure.
without following procedure. My lord, if this court function without a judge, an order is passed and judgment is passed and ask the party to follow it without a judge, how can that be? In National Highway Act, the first step is to declare certain state highway as a national highway. After that, it is followed by appointment of a competent authority. Now, there's no competent authority, and they're acquiring land, and construction is going on. It is a great injury to the sentiments of the landowners. My lord.
This acquisition should be under the NH Act or the RTCR, that 2013 Act. The beneficial provisions of that
my
are
lord,
applicable in Nagaland.
my lord, as per section 105 of the right to fair compensations, only the components of a compensation is applied to the NHA and not otherwise. As per the Tarsim Singh, which has been laid on by the Tarsim Singh case, Supreme Court. And then there's a notification issued by the central government regarding the applications of the first and second and third shares, because NHA exclude Land Acquisition Act, and Right to Fair Compensation Act, it excludes NHA Act. But then there's a window provided by Section 105 of the Right to Fair Compensations,
Yes.
where this can be applied, but only to the compensation. My lord, here, 83 petitioners are before you on the architecture of 7 pillars. The first one is inputting the notifications issued by the Chief Secretary. Chief Secretary issued 2 notifications. In 2023, Chief Secretary issued notification saying that land compensation will be paid in all the national highway construction. But again, in 2024, he cancelled that. We do not know under what provisions of law he was issuing, whether it was under Land Acquisition Act, General Act, or Right to Fair Compensation, or NHA, or State Highway. We do not know. Then, by 2025, they started constructing the highway. My lord, the only question is whether Nagaland Assembly resolution is required or not in this present case, because the NHA is there. That is the issue. Now, my lord, Article 300A says, no person shall be deprived of his property, save by authority. That you know very well. And this article has been borrowed from the Universal Declarations of Human Rights 1948, and
That's true.
that you know very well.
It's a constitutional right now, if not a
Yeah,
parliament right. You're appearing for 3 to 6?
Yes,
3 to 6. And highway authorities represented?
no one,
No one. You filed your affidavit.
not yet.
So that's great. What would be
That
your,
is what I am saying.
what would be your prayer today, sir? We'll admit it.
Yeah, admit the petitions and a hearing should be started, because it is getting delayed. It is like a city burning and fire brigade are saying that you don't have water. Construction is going on without following the due procedure of law.
Just 3, 4, 6, and 7. 7 is. Seven is also there.
7,
6.
This was by mistake.
6.
It was mistakenly written. I think you accepted notice on behalf of 3 to 6, right? Steps of notice have already been taken, right? On 1 and 2. Already.
Already. My lord,
Yeah, petitioner.
on 8th September,
You've
on
taken
8th September 2025, Justice Kalin Rai Sharma, his order is very clear
notice.
that the parties are well aware of they're conscious of the fact that a writ petition is pending against them. And on 7 August 2025, Justice Kohn has made a last adjournment, saying that this will be the last adjournment. But even from August, September, October, November, December, now already about 8 months, still they are praying, they don't have a ground, my lord. They don't have a ground to stand at all.
Anyway, so heard Mr.
Lordship, Here that respondent number 1 and 2,
Yes.
they are the principal respondent.
Yeah.
And 3, 4, 5, and 6 we are only a local felicitator.
Yes, yes. And the as per office note dated 30th May, the service has been
Yes, yes.
delivered to 1 and 2.
Yes. Then
But they have not filed any.
Lordship, the petition
They have not appeared also.
no.
Appeared also.
The petition seems to be filed in the month of March 2025. But notice upon the respondent number 1 and 2 was completed only on 8th September 2025.
30th May. 30th May, as per the office note.
Respondent number 1 and 2.
Delivered on 1/4/2025,
Okay.
as per this
So
office.
by counting, if we count from the
Long time.
March, now it's long time.
Long time.
But even notice upon the principal respondent was completed only in the belated stage.
Mhm.
And now the problem is without the principal respondent.
Yeah.
Our part is we are facing
Yes.
a lot of problem. And over and above, my lordship here, PWD National Highway we have, they are the nodal department. They are not completed. There is a non-choice of necessary party. Now they have completed the chief secretary, that is by statutory implementation chief secretary was completed. And followed by the commissioner secretary, land and revenue. So
Both these addresses are in Delhi.
yeah. Respondent 1 and 2.
It's delivered actually. It's served also. As per the postal tracking of postal tracking is also here.
My lord,
Mm.
on 8th September 2025, Justice Kalyan Rai has narrated the whole sequence of events, and it is very clear that the respondent number 1 and 2 they have already received. And in fact, this is the evidence, my lord. Yes, it is on record. National Highway Authority of India, they have written a letter to Director NHI District to act on their behalf. Now, this shows that they have already received the notice. And this has been clearly reflected by Justice Kalyan Rai. Kalyan Rai.
By the order dated.
By order dated 8th September 2025. And in fact, I received this from the court itself.
Yes. Mr. Heard Mr. N.K. Aswini, London Council, for the petitioner, Mr. Who submits that though notice upon respondent number 1 and 2 stated to be the main respondents with regard to the issue at hand, but they have not chosen to appear or file any affidavit. Learned additionally appears on behalf of respondent number
4, 5, and 6.
3 to 6.
Yes.
3 to 6. The state respondents, the learned additional AG also submits that the respondent number 1 and 2 are the main respondents with regard to the issue ventilated by the petitioner regarding acquisition of land. You're in a way a formal party, in a way. Anyway, I will not write that. Full stop. However, no affidavit has been filed on behalf of the state respondents as well. The learned counsel for the petitioner has drawn my attention to the order dated 8/9/2025 passed by this court earlier. Full stop. I have also perused the office note dated 30/5/2025 indicating service upon respondent number 1 and 2. It appears that subsequently the petitioner was directed to take fresh steps upon 1 and 2 through CGS, through the Central Government Council, and which was done so, right? It was done so.
Yeah.
And an affidavit of service has been filed on 4/8/2025 regarding service of notice on the CGS, Central Government Council. As reflected in the order dated 8/9/2025, and also pointed out by the learned counsel for the petitioner. Where was it? It was in which page? This letter which you showed me?
It is from the court only I received.
Okay. From the court.
This is the one, my lord.
There's an internal communication dated 2/7/2025 from the Deputy General Manager to the Executive Director, NHIDCL Regional Office Kohima, regarding WPC 39/25. That is the present case. Full stop. In this context, as reflected by this court in order dated 8/9/2025, the said letter shows that the the Highways Authority, National Highways Authority are aware of the pendency of the said writ petition. In the order dated 8/9/2025, upon considering the aforesaid aspects of the matter, the court held that service upon respond number 1 and 2 is complete. Full stop. 2/7/25. Despite the elapse of time indicated by the aforesaid materials, the respondent number 1 and 2 have not appeared nor filed any affidavit. So what is to be done? We can admit it. In the meantime, they can file an affidavit if they want.
Yes,
But it's
yes, my
unlikely.
lord, yes.
It's unlikely they have not appeared.
Unnecessary, just admit the petition. In a recent Madhya Pradesh High Court, even for 4 months.
The process should be allowed to be completed.
No, but they have not appeared at all.
Now, it's by way
They have not
of
appeared.
substitute notice.
No, sufficient notice has been given and they are very much aware of that. Now, Madhya Pradesh High
Only
Court,
one option is there. I mean, the service is there. It has been reflected in the court also.
yeah, petition may be admitted and then hearing should start. And if they want, they can file a reply affidavit even after admissions.
Full stop. At this stage, I find force in the submission of the learned counsel that considering the elapse of time, the writ petition may be admitted and posted for hearing. And in the meantime, the respondents, especially R1 and R2, are at liberty to appear and file any pleading. Full stop.
Lordship, respondent 3-6 also may be allowed to file the affidavit.
They can also file.
Yes.
Yes.
That's what we are.
The respondents, you just write respondents. Okay. Accordingly, the writ petition is admitted for hearing. It is made clear that all respondents are at liberty to file affidavit in the meantime. List the matter for in the hearing column after
3 weeks.
after not a little more.
4
Little
weeks.
4 or 5 weeks. No? 4 weeks. 4
4
weeks.
weeks.
After 4 weeks. You can take this, sir. You can take this. Shall I give it?
For admission, item number.
Yeah, please, Lordship.
Yes.
Lordship, here pleadings are completed and today the matter is fixed for admission.
Admission. Pleadings are completed. We'll fix it for hearing then.
It's a short matter.
Lordship, it's a short matter, so if the Lordship pleases, then maybe taken up today or maybe after part 1, once the listed matters are over.
They have a bit of a time constraint till 4, so not a problem. But we can keep it on hold for timing.
Very well.
If
After
time
part-
permits,
Yes.
then we can
Very
take it up or after. We'll fix it next week. Fix it next week. If another date is given, then it's best to admit it. Otherwise, something relating to medical attendant rules.
Yes, regarding the appointment.
Keep it on hold.
Very well.
Obliged.
For orders, item number 3.
Yes,
For the respondent number 9 and 10. We have already filed a compliance certificate.
you file affidavit.
Already filed.
Yes,
Your Lordship, service report on respondent number 11 and 12 is still evident.
still awaited.
Yes, Your Lordship.
It's a very old content.
Yes, Your Lordship. Your Lordship, I seek permission to take fresh steps upon respondent 11 and 12 by dusty service.
Yeah, that would be best. 11 and 12. 13 has been served, I think,
Mm,
but 13 is done.
Yes, Your Lordship.
Sorry, you're appearing for which respondents? 1, 2, 3,
I'm for 9 and 10. 9 and 10.
only 9 and 10. Others all served.
Yes, yes, Lordship.
So are we to understand that except 11 and 12 all are served? Or not sure? Because heard learned counsel, you are Miss Chang,
Sigmo.
learned counsel for the petition and additional AG representing respond number
9 and 10.
9 and 10. System. The learned counsel for the petitioner submits that as service report upon respond number 11 and 12 are still awaited. The petitioner may be permitted to take fresh steps. You'll take dusty,
Yes, Your Lordship.
fresh steps by dusty service. The prayer is allowed. Dusty service may be undertaken and compliance affidavit filed. Will not say anything about the other respondents solved or not. If anything is left, you can
Yeah,
pick.
yes, Lordship.
The petitioner side is also at liberty to take fresh steps with regard to any other respondent that may be yet to be served. By speed post and oblique or dusty service. Just giving list the matter after 3 weeks.
Yes, Your Lordship.
3 weeks. That's a whole matter.
For order, item number 4.
Yes, Mr.
May I please, my lord, lordship, in this matter, I'm representing the respondent number 1.
1.
Yes, the other respondents, your lordship, the
Awaited.
notice upon them is
Still awaited. How many
Yes, sir.
respondents?
2, 3,
yes.
and 5. 2, 3, 5. 2, 3, 4, 5. Your Lordship, 2, 3, 4, and 5.
Third Land Council and Mr. Angami for a respond number 2, 3, you're for
No,
1.
no, I'm for 1, madam.
Respond number 1. Good stop. 5 respondents have been implemented. Good stop. Have you filed any reply or something?
Lordship, in fact, this
necessary.
matters pertains to regularization. So the other respondents are the main respondents.
Chief Secretary
Yes.
has been
I have-
discussed that day.
Yes,
Sometimes
yes, very limited.
Chief
role.
Secretary is the overall head.
Yes,
So in all cases may not be necessary.
Correct. correct.
So you others are 2, 3, and 5, right? 4 is served.
2, 3, 4, and
2,
5.
3, 4, and 5.
They are awaited.
Yes.
Press steps in place.
Yes, Your Lordship.
Same.
Yes, same order.
Same order. The petitioner and the Land Council for the petitioner submits that the petitioner side shall take fresh steps upon respond number 2, 3, and
4 and 5.
4 and
4 and
5 by dusty service and file compliance certificate. List after 4
4
weeks.
weeks. 4 weeks. Your
4
Lordship.
weeks.
For orders, item number 5.
May I please, my lord? The lordship, in this matter, I am appearing for respondent number 2. Your lordship, the respondent number 2 has already been transferred. And therefore, the petitioner may be allowed to take fresh steps upon the new respondent number 2 is a secretary to the PhD department, my lord.
1 and 3 are represented.
No, your lordship.
Okay. The good old problem of contempt petitions. People keep on changing.
Correct.
You know, we have to speed up the contempt matter.
Correct,
right?
correct.
It should not become, have the fate similar to the execution proceedings in civil cases.
Correct.
It is another story, and
Correct.
we have to do something about that also.
Yes.
The Supreme Court has taken steps now. We have to do something about that also. But contempt is not a mode of execution, we know, but still indirectly it becomes.
Totally agree.
Learned Counsel, Mr. Angame submits that. In the meantime, the respondent number 2, incumbent, has been transferred. Full stop. In view of the same, the petitioner side shall file an I for implement of the present incumbent with regard to respondent number 2. This is Secretary, PHED, Government of Nagaland. You are representing 1.
No, I'm representing 2, man. Only 2.
Okay. The respondent number 2 was represented by Counsel Mr. Angame. And what about 1? Usually you represent. Oh, this is
No, your lordship.
Here,
The chief secretary is not there, man.
2, 1 and 3. So what will you do? It's fresh steps.
Just a little.
Same. Fresh steps by the state officials can be supplied. The state and submit compliance list after 4 weeks.
Yes, Your Lordship. Much obliged.
I'm deeply obliged.
In the meantime, you file that IA.
Yes, Your
So
Lordship.
it can be 3 weeks. You file the IA, because otherwise you lose time. You
Yes,
lose
Lordship.
time. It can be 2 or 3 weeks also for filing the IA. IA is a small step, right?
Correct.
So list the matter after 3 weeks.
Much obliged.
Obliged.
For orders, item number 6.
May I please, Your Lordship? Lordship, as per office note, await service report upon respondent number 4.
Is awaited.
Yes, Your Lordship.
You are for
1, 2, and 3.
okay. Miss, good name, please.
Theakrila.
Learned counsel for the petition. Respondent number 1, 2, and 3 is represented by learned counsel.
No,
Yes. Have you filed any counter affidavit?
yes, I filed my objection.
Full stop. Affidavit, an opposition has been filed on behalf of respondent on behalf of the said respondents. Full stop. Service report is stated to be awaited with regard to respondent number 4. Shall we await or you take press steps? Await. How long back? Just take 8/4/26.
Yes, Your Lordship.
Still. We will speed up these things, right? So maybe. Okay. 4 is. The address is not complete.
Honor of the track. Yes.
The address is not complete. In the cause title, madam, please look. You have to incorporate this, what should we, it's up to you, your choice. Should we await or press steps?
Await, Your Lordship.
Okay. Service report upon respondent number 4 may be awaited. List the matter after 3 weeks.
For orders, item number 7.
No, please, Your Lordship. Lordship, service upon respondent number 4 has been completed. And I filed my affidavit of compliance on 27/4/2026.
Respondent number 4.
Yes, my lord. The private respondent. Right, yes.
Do I need to see the affidavit? It's okay, and then you file. Is it there?
Yes, my lord.
Otherwise, it has to be brought on record. Learned counsel for the petitioner submits that justice service was undertaken upon respondent number 4, within bracket private respondent, and compliance affidavit has also been filed. None has appeared. Write it later. Service upon respondent number 4 taken to be complete. None has appeared so far on behalf of said respondent. Mr. Learned Senior Government Advocate appears on behalf of respondent number 1, 2, 3. Any TCR won't be necessary? TCR?
Might not be necessary, my lord. I think those all the orders.
Subdivisional customary. I think record will be, you filed the objection. You filed any affidavit?
No, I have received a simple instruction from the Deputy Commissioner.
Instructions.
Yeah, simple instructions from the Deputy Commissioner. Wherein he has said that we are willing for retrial, de novo retrial of the matter.
On the matter. Yes.
Proceed, can you use this?
You can put it down. Would you like to put it down in an affidavit? Would you like to? Put
No.
Instructions in an affidavit?
I will not be filing any affidavit.
Okay, you're not filing it.
Because I have a one-line instruction with.
Okay. The Learned Senior Government Advocate submits that the state respondents would not be filing an affidavit. However, a brief written instructions has been received from the Learned
Deputy Commissioner Fake. Deputy Commissioner Fake is respondent number 2.
Respondent number 2. Post it for hearing the matter.
Fine, my lord.
No records are necessary.
No reports are necessary.
Should I keep a copy of
The respondent
instruction?
number 4 is yet to appear, my
Not
lord.
necessary. Should I keep a copy of the instruction in the file or a photocopy?
It was addressed to me.
The revision was filed for what actually? There
Challenging
was a
the order
judgment of
dated.
this court. Judgment of this court.
No, my lord. Challenging the order dated 10 February 2025 passed by the DB's court. The customary
the
court.
Basha.
Yes. By this order, they upheld an order which was already questioned set aside by this honorable court, my lord. So I do not wish to go back again to that court, my lord. It's a waste of time.
Okay.
So I've prayed for to transfer my case to a competent civil court, my lord.
The said written instruction has been placed before the written instruction communicated by later dated 10/3/2026 has been placed before the court, and a copy may be kept in the record. It is stated in the instruction, the office of the Deputy Commissioner is willing to abide by the directive of which court, honorable court, which court? This court?
This court, I believe this court.
Directive of the court for retrial under Rule 31 of the Administration of Justice and Police in Nagaland Act 1937. This may be kept. And should we fix it for hearing?
Fine, my lord.
Finally,
It's fine, my lord. But the respondent number 4 is yet to appear, my lord. The private respondent number 4.
yes, they are yet to appear. That's true. Okay, so we can wait for some time. We
Fine,
can
ma'am.
wait for some time and
Yes,
pick
ma'am.
next week or thereafter. Next week
Fine,
or
ma'am.
after 2 weeks.
After 2 weeks.
Okay.
Much obliged.
Please, the learned counsel for the petitioner fairly points out that perhaps the matter may be posted for hearing after giving some more time for appearance, if any, of respond number 4, right? So list the matter after 2 weeks. In the orders column, it will remain in the orders column. Admission number. No, it has come for orders to it has come for orders is completed. Yes, leave it, orders. Don't worry, that's not a problem.
Flash man.
For orders, item number 8.
Lordship, I'm appearing for the petitioners.
This was 7, right?
My lord.
7. This was order matter.
Yes.
Yeah.
I'm appearing for the petitioners, Your Lordship. Service upon all the respondents is complete.
Mhm.
Amended cost title is filed. The
Mhm.
state and all the respondents are appearing today.
All the.
Yes, affidavits may be directed upon the state of Nagaland. Because notice was issued on 20th of February 2026.
My lord.
Since
if I
then,
may
no
talk,
affidavit has been filed.
make my
Still, we should come to it. Just a minute. Just have a look at the cost title. File is voluminous because of many petitions.
Yes, just that.
Large number of petitions.
Yes.
Just a minute. Okay, sir. You're representing
for the state. For the state respondent number 1, 2, 3, and 4. My lord, here, the present matter pertains to the appointment of Hindi teachers under central sponsor scheme. The order in this case was passed on 20th February 2026. However, a direction was passed by this honorable court directing the petitioners council to make necessary corrections in the course title,
Which has
since
been
there
done.
was certain defectives. However, the very amended course title, which was made available to me only on 20th April, just few days ago.
Okay.
Thereby, I have communicated the order of this honorable court along with the copy of the writ petition on 22nd April. Therefore, I may be given 4 weeks' time to receive instructions.
Have you filed any affidavit earlier?
No, I'm yet to receive instruction. I've served the copy to
And
the
sir, you're appearing for the union.
Yes, ma'am.
You filed any
I
affidavit?
have not received any instruction. So we'll be given the following side. In fact, yes, one number 5 is a problem.
Your Lordship, affidavit may be directed. If it takes 8 weeks, then no issues. But affidavit may be directed because it's the lives of 1161 teachers. It's not that just because of the cost title, amended cost title was filed, it was served, but nothing in the petition has been changed. No statements have been changed. The statements are intact. The state was aware since 20th of Feb.
Okay.
Affidavits may be directed.
Heard, Mr.
That's-
You-
My name is S. Das.
As thus learned counsel for the writ petitioners who are 1161 in number. 5 respondents have been implemented. Learned counsel, your senior government.
I'm additionally
Additional AG, additional AG, learned counsel appears on behalf of state respondent.
1, 2, 3, and 4.
Respond number 1, 2, 3, and 4. Learned CG, your CC, learned counsel appears on behalf of respond number 5. Please stop. The learned additional AG submits that upon the direction of this court, the cost title was amended, and he has received the amended cost title
Only on 20th April.
on 20th April 2024, 26. Full stop. And it is submitted that he shall take instructions from the respondents and file affidavit if the union R5 has also not filed any affidavit. Full stop. The respondents shall take necessary instructions and file their respective affidavits even for the for a better adjudication of the matter. Full stop. This is the matter after.
Your Lordship, a date may be fixed because I come from Calcutta. Any date as Your Lordship may deem fit.
Why not?
After 4
It's
weeks
a
is which date? After 4 weeks would be what date?
I'll give you a date after 4 weeks.
28, 27 if Your Lordship.
No problem. So walk it out amongst yourself.
Okay, one second. May, any time in May?
And because we do not know how many matters have been distributed.
What date in June?
You just, that's your also to give it.
Yes, sir. Only third.
Not on Wednesday, not on Wednesday.
Thursday, 4th June. 4th of June, Your Lordship.
4/6/2026, right?
I'm grateful.
For orders, item number 9.
May I please, Lordship? Lordship, this IA is filed praying for deletion of respondent number 24, Srimati Esther Kafo, serving as IE resource person at Flag District, Nagaland, and petitioner number 26, Srimati Imnasan Lai Imsong, serving as IE resource person at Mokchung Village, Mokchung, Nagaland. Lordship, here in this matter, both the petitioner, that is petitioner number 24 and 26, they no longer want to pursue the matter. So I pray that this honorable court may be pleased to allow this application and delete the name of respondent petitioner number 24 and 26 from the area of
24 and 26.
Lordship.
You have no issues?
Lordship, I'm representing the respondent number 1, 2, and 5.
Ah.
And I have no issue. As far as respondent number 1, 2, and 5 is concerned.
Lordship,
3, 4, and 6. You are supposed
Lordship,
to
I'm for respondent number 3.
only
I
3.
thought this is a copy of the IA, but I have no objection to the withdrawal.
Have a look. And mission director 6 is applied. Mission director.
Lordship, regarding
Have it here.
respondent number 6, I've taken steps through Dusty.
You have, sir.
I filed my affidavit also.
You Miss Chris.
Lordship.
Learned counsel for the petitioners 28 in number. Full stop. The Ms. Tangami represents respondent number
1, 2, and 5.
1, 2, and 5. Full stop. Madam,
AGA
learned
for
yes for respondent number 3. Full stop. And 4 and 6 you have served Dusty.
For 4, I've served it through speed post as per the court's order, and for 6 through Dusty.
Okay, both are served.
Lordship, yes.
It is submitted that both respondent number 4 within brackets speed post and respondent number 6 Dusty have been served. Compliance affidavit has also been filed. Today the matter has come up for passing orders on the present interlocutory application, which has been filed for striking of the names of petitioner number 24 within bracket, you give the name please, and 26 in the read petition WPC 165 of 2025. It is stated and submitted that these two petitioners no longer wish to pursue the writ petition and are not desirous of continuing as petitioners, and hence seeking their seeking deletion of their names from the list of petitioners in this writ petition. The learned counsel, for the aforementioned learned counsels for the respondents, submit that they have no objection to the said prayer. Accordingly, the interlocutory application is allowed, and petitioner number 24, Mr. Capo, and 26, Imsong are hereby struck off from the list of petitions in WPC so and so. The IA is allowed and disposed of. Yeah. So what the striking off may be done by hand or fresh cost title?
I'll be filing the amended memo of parties.
Okay. The petitioner shall the petitioner side shall file an amended memo of parties in the writ petition. In the meantime, list the matter after.
Lordship, as per the court's order dated 20 March 2026, it's fixed on 12th of May.
12th of May?
Yeah, it's fixed on 12th.
What's the main case?
Lordship.
Is the matter on 12/5.
Obliged.
Obliged.
For orders from the supplementary cause, please. Item number 12.
Please.
Left is the lordship.
Could you-
Lordship, I am allowed to produce the case directly.
Yeah.
The updated case there. Lordship, the updated case diary starts from 1 5.
Mhm.
Now the statement of the accused has been reported. And from the statement, it appears that lordship may kindly come to
Well, page number of the,
page number is not there. However, case diary number 5.
No.
Lordship. The next page. This is a statement recorded by the IO, and relevant will be next page, starting from the lordship, starting from last 4 paragraph, where it said that I will respectfully state that we dated 2 times. The first occasion where there wasn't any physical touch, but on the second date, very important, second dating, there was
just a minute, where are you reading? His statement on the second page.
the second page.
One day while
Or-
I was in the bank, from there.
second last 4 line.
The main thing.
Read petition.
The main
Read
petition.
Yes.
Oh, I see. I think it's obvious. Oh, yes. It is also fixed. This is also an observation that the subject to
The outcome.
consent of the parties, effort may be made to dispose of the writ petition. So anyway, that's an open matter.
Yes, yes.
That's a
File a counter in the meantime.
you file an open. So we fix it on Monday along with
Please,
this. That will
please.
be best, I think. Third, you are appearing in person.
In person.
Please, Your Lordship.
Mr.
Major.
Major Love.
Love Kumar, Land Council, sorry, the petitioner in person. Full stop. Learned CGH.
Did you see?
Yes, on behalf of respondent number.
Respondent number 2. Respondent number 1. Only one respondent in the main petition.
Okay. Respondent number 1.
Yes.
The sole respondent.
All respondent in the main petition. Yes.
2 is yet to be implemented.
Yes.
Some rifles, yes, I think maybe some rifles. The IA 72 of 2026 has been filed. Seeking implement of the authority of Assam Rifles and also for vacation/modification of interim order dated 24/4/2026 passed in the main proceeding WPC 57 of 2026. Full stop. The IA 74 of 2026. This has been filed by who?
By the sole respondent.
Respondent number 1.
Military.
The
Main respondent.
This has been filed by the sole respondent in the writ petition. Seeking vacation and modification of the same interim order dated 24/4/2026 in WPC. Full stops. It appears that the main writ petition is fixed on 4/5/2026. Full stop. Mr. L. Kumar, Major L. Kumar, submits that he's also received a copy of the second IA only today.
Yesterday.
Only yesterday, and he may be given some time to file counter if any. Reply if any. Right. Full stop. You can list both the IAs on 4/5/2026 along with WPC 57 of it. That will be best.
Please, Your Lordship. They may be asked to file the counter with all the relevant documents, Your Lordship. In the IA, they're not there.
The respondents are at liberty to file their counter in the main petition.
In the main petition, Your Lordship, they have to produce the documents regarding the posting, Your Lordship.
Along with documents, they are at liberty to file their pleadings in the main writ petition along with necessary documents. That's all.
Yes, Lordship.
Oblige, Your Lordship.
4/5.
For admission, item number 2.
Can we finish this matter?
Yes, Lordship.
If it helps you, definitely, but I would like to today complete by 1 o'clock.
No.
Otherwise I may get late.
I believe we can.
Otherwise, of course, if I had one more day also, we
Yes.
could have kept it part third. Even now we can, but you have to submit online, and sometimes because of documents, it becomes a problem. Okay. Yes.
May I please, Lordship? Lordship,
Proceed.
here I'm seeking appointment on land ownership basis, as well as I'm challenging the appointment of private respondent number 5 and the screening test committee dated 17/8/2023. Also, the case is that CPMAS Sub Center, Chief Medical Officer Dimapur, under the Health and Family Welfare Department, was shifted and constructed in the year 2011. on the plot of land donated by the petitioner's uncle. So namely Shri Visakole Kutso and Shri Seyeleto Kutso.
So this primary health center.
Lordship.
Primary health center PHC was constructed on the land donated by the petitioner's uncle.
Two of them.
Okay.
It was shifted to the plot of land in the year 2011, and it was measuring around 200 feet into 100 feet. That is approximately about 30,000 square feet. And a written agreement was executed on 20th of July 2011 between the parties. That is agreement is at Annexure A, page 15.
50. Page
15.
15.
Type copies at page 16.
Okay.
Worship, I may be allowed to read the agreement.
Yeah.
Zipima Village Council and GBs and Mr. Madhyo Punyo held a meeting on 20th of July 2011 regarding the plot allotted for construction of village dispensary free of cost as per the 3-point agreement mentioned below. Fourth grade jobs to be given to the landowners. And as per the agreement, there will be no objection whatsoever from the landowners concerned. And if in future there's a change in location of dispensary, the landowner should be consulted first. So the copy was given to the CMO Dimapur, and he have received as well. So that was the agreement executed between the landowners and the department as well as the GPs of the village. And as per the agreement, Lordship can come to state affidavit. Annexure A, page 8. Type copies at page 9.
The two affidavits are there. 145.
Yes.
105.
One is for private.
Private response.
For the state.
And for the state.
Yes, Lordship. Type copies at page 9.
Page?
Page 9.
Yes.
So, as per the agreement, there were two landowners, both are brothers. One of the brother, namely, is at serial number 2, Sri Seileto Kutso. He was appointed as sweeper. And as per the order, it's not a regular appointment. It's on fixed 3,000 per month. So when the post was offered to me, and since both the brothers have donated the said plot of land, the department have stated verbally that as and when regular vacancy arose.
It was donated by the petitioner's uncle. Then
Petitioner's father is the elder brother of the landowner of the
Kutsu.
Yes, Lordship.
So, and the petitioner is the son of.
Is the nephew of the two landowners.
Two brothers donated.
Yes.
Both sons.
Yes.
Okay. So he was appointed. Is he still continuing?
Yes, he is still continuing. But Lordship, there were two brothers who have donated the land.
Okay.
And moreover, one of the brother was appointed. However, he was not given a regular post because at that point of time, there was no vacancy. and he was appointed on fixed as sweeper. That too, monthly, it was only 3,000 rupees.
Fixed pay.
Yes, fixed pay. And till that, he's serving as fixed pay. So as when vacancy, regular vacancy arose, preferences will given to us, they have stated. And in the year 2021, a fourth grade post of medical attendant fall vacant in the said subcenter. Such, the petitioner, being the nephew of the two landowners, he have applied for the post. And he have submitted his application by application dated 27/7/2021. It's at Annexure B, page 17 of my
Copy of
petition.
petition. Read petition.
Yes, Lord.
Page 27.
Page 17, Annexure B, along with my necessary documents.
All right.
So in my application also, I've clearly stated that I'm applying for a said post on landowner as per the agreement executed. And my application was forwarded by the chief medical officer by letter dated 28/7/2021. It's at Annexure C. And STO Civil Mizi Pima, as well as the village chairman, has also issued a lands certificate stating that I am the nephew and my uncles, they have donated the said plot of land for the establishment of the sub-center.
Okay. It was forwarded.
Yes, it was forwarded
Thereafter,
to the principal director.
but nothing happened.
Thereafter, the principal director, by letter dated 28/11/2022, it's at Annexure F, page 29. The principal director has written a letter to the chief medical officer on subject sitting of a screening committee selection board for appointment of grade 4, strictly in compliance to PNAR office memorandum number so and so dated 7/12/2016. So the screening, the principal director have written letter to the chief medical officer for sitting of a screening committee, but strictly in compliance of the office memorandum, which I will come later.
OM is the governing law, right?
Yes, OM is the governing law. So I also received a calling letter from the department for the selection process to sit for the test, and I've also participated in the selection process. However, my participation was
pursuant to an application which was forwarded.
Yes, Lordship. And along with me, there were some other applicants as well. And after the selection process, the meeting minutes for the interview of grade 4 appointment at Sipima was passed by the selection committee. It's at page 31, Annexure G. Along with the marks obtained by the candidates. That is at page 32.
There was only one post.
There was only one post.
The private respondent was selected.
Yes.
Rather than you.
There were 8 candidates. So the meeting minus was forwarded, and even the marks secured during the selection process, I've annexed and it's at page 32. That also I will come later on. And the attendance sheet of the officers who were present at. And thereafter, the chief medical officer has forwarded a letter to the principal director recommending Srimati Seinyo Tepa for appointment to the post of medical attendant. And that is in Annexure H, page 34. So on learning that, being aggrieved, I have submitted a representation to the principal director. However, hoping that my case will be considered. However, respondent number 5 was approved and appointed. So my contention here is, firstly, the principal director has submitted a letter to the chief medical officer for screening tests strictly in compliance of the office memorandum dated 7 December 2016. So Lordship can kindly come to the office memorandum, page 37, Annexure K.
This is the OM.
Yes. So as per the records, the screening committee selection board was constituted in terms of the said office memorandum. However, by looking at the office memorandum, it was not constituted as per the said memorandum. Because here, Lordship will kindly come to para 2 of the office memorandum. Further, all direct recruitment vacancies in grade 3 posts which are outside the preview of the NPSC as well as in grade 4 posts in a department, including such vacancies in the district offices at that department, shall be filled up based on recommendation of the following departmental screening committee, except police department. Number 1, director, head of the department. Number 2, representative of concerned administrative department not below the rank of under secretary. And number 3, representative of PNAR department not below the rank of under secretary. And 4, a senior officer of concerned directorate not below the rank of deputy director in charge of administration. So the screening committee selection board, which was constituted, was in violation of this said office memorandum. Why? Because Lordship, Lordship, can I come to page 33 of my petition? Page 33 of my petition.
Page 33.
33. The persons who were in the screening committee selection board, these are the officers who were present. Number 1 is Selimla S. Sanctum, SDO Mizipima. Number 2 is Tamjam Sanap, MO, in charge CHE Mizipima. And number 3 is Anthony Su, Deputy CMO Dimapur. 4 is Dr. Khuzunye so-and-so, ADC Chumukidima. And number 5 is Dr. Limatullah Iyer, CMO. So the selection board, who are present, the officers, is completely in violation of the office memorandum. Because as per the office memorandum, number 1, there is the director, head of the department. He should be a member and present, as well as there is none from the representative of PNAR department. As such, the departmental screening committee must be treated as null and void, Lordship, since it's a violation of the office memorandum. And secondly,
Any case law to that effect? Just asking.
no, Lordship, but since the records are very clear, it's in violation of the OM. And as per the letter submitted by the principal director, the screening committee selection board was to be constituted strictly in compliance of the said office memorandum. And secondly, the screening committee has recommended, Lordship, this is also very important. Yes, Lordship. Secondly, the screening committee has recommended Srimati Seine Tepa for appointment to the post of medical attendant. But however, surprisingly, respondent number 5, private respondent number 5, who was not even recommended by the screening committee, was approved and appointed illegally by the respondent authorities. Because after the selection process, the selection board, they have submitted the records to the director, principal director. Lordship, you kindly come to page 32, the marks obtained by the candidates. Lordship, come page 32. These are the marks obtained by the candidates after the screening test.
Yes.
Number 8 is Seinyo Tepa.
Yes.
He scored out of 50 marks. He scored 37.5 marks. So she has scored the highest mark. So the selection board has recommended his name for appointment. And where is respondent number 5? It's at serial number 5. Nisa Sino. Out of 50, she scored only 31 marks. However, even though her name was not recommended, she was appointed illegally. And for petitioner, I have scored 33 marks. So the respondent number 5 marks was lower than my marks as well, Lordship. And the stand taken by the private respondent is that the name Seine Tepa, who was recommended, she is not an indigenous inhabitant, so she was not appointed. So even if she was not an indigenous inhabitant, the government has every right not to appoint her. However, the one, serial number 2, Ngulanye Miyase, she scored 36 marks. So her name should have been approved and appointed. However, the respondent authority has illegally appointed respondent number 5. So on these two grounds, the appointment of respondent number 5 should be terminated.
And what about the aspect of land donation? No.
Yes, aspect of land.
How's the land donation appointment system? I know some
Yes.
knowledge regarding that.
I
Suppose if it's one post selection process,
no, sir.
then if a person claiming selection on the basis of land donation is applied, then it cannot be. How can it be applied then? Because otherwise, it will be like or if there are more posts than one, then it is.
However, preference should be given to the landowner because
In case of one post also.
yes, because we have donated
Otherwise-
our land, and there's an agreement, written agreement,
Or anyway, we come to that.
and preferences will be given to the landowner. That's what has been stated in the agreement as well. And there are two brothers who have donated the land, as I've stated before.
So,
One brother.
what is the governing law regarding the appointment on the basis of land donation? I know about this process system
No,
that land donation you get
Yeah.
can get an appointment. It is governed by an office memorandum.
Yes, I have annexed
forgotten
the
actually.
office member as
No,
well.
no, this is regarding grade 4
Yes.
appointment, but land donation specific appointment. Is there any office memorandum
Yes,
regarding
Lordship.
that? Anyway,
It's in my annexure, page L. Or annexure L, page 39.
land on.
Lordship.
Okay, yes, this is the one.
5th March 2018.
Notification dated. Okay. Do they have to go through a selection process or the family, any member of the family can be appointed anyway? So notification dated. Let us proceed, not get detained by that.
So, Lordship, my only contention and my prayer before this honorable court is that appointment of private respondent number 5 was in violation of the office memorandum because the selection board was also not constituted as per the office memorandum. So the selection process should be treated as null and void. And moreover, the private respondent number 5, he was not in the merit list as per the marks obtained by all the candidates. So she should never have been appointed. However, she was appointed illegally. So she should be terminated. And with regard to my claim for appointment on compassionate or on land ownership basis, since my two uncles, they have donated the plot of land to the department, and there is a written agreement, and the department already clearly assured that as and when regular vacancy arose, opportunity will be given to the brothers. So when vacancy arose, and I've submitted my application, I was not considered. My prayer was not considered. And the stand of the state as well as private respondent that we have already claimed the benefits of appointment. But however, I have stated before, that was on contingency basis on fix of 3,000 rupees. And one of the brother has not availed any benefit from the department till date. That's my humble submission.
Yes.
Your Lordship, with regard to the agreement dated 2011, that annexure A of the petition, Your Lordship, this agreement was made between the landowners and the village council. Nowhere was the department a party in this, Your Lordship, to give grade 4 jobs to the landowners, Your Lordship.
The such agreements are made with the department.
No, Your Lordship. If you look at the agreement, it was purely between the landowners and the village councils themselves.
Village
Your
councils.
Nowhere is government a party here, Your Lordship.
No, that is what I'm asking. That in such agreements, Is the government usually a
Yes,
party?
your lordship.
They are
Government is also a party.
because the landowner, that means the landowner has to make an agreement with the government.
Government, your lordship, yes, because the government is taking the land. But here it's between the landowners and the village council.
Okay.
And the second point here is, your lordship, in 2014, the petitioner's uncle was appointed as a sweeper and he is serving till date. As per the
Petitioner's cousin brother.
uncle, your lordship. Uncle, his uncle.
This.
Son of the.
I'm the nephew.
Okay.
The
Petitioner's and nephew
petitioner's
of the
father, the two
Petitioner's
brothers are
father,
the
petitioner's
petitioner's
father and his brother.
Yes, petitioner father is the eldest.
They donated the land.
Yes, yes.
Petitioner is one son.
Petitioner father, brother, two younger brother have donated the land.
Okay. Nice. So petitioner's uncle was appointed as sweeper.
Yes, your lordship. And as per the notification dated 5 March of 2018, clause 3C, it clearly states that it is not the policy of the government to provide employment to landowners in perpetuity.
That's true.
Employment of landowner is permitted by a verifiable and valid agreement is limited to the person first appointed as landowner in government service and does not entitle his descendants for further employment on his retirement.
Even if what about the nature of the appointment, which is also containing that if an appointment is relatable to a land ownership, a land donation, then such an appointment will be a regular appointment, isn't it?
Yes, your lordship.
Permanent job,
Yeah.
permanent job has to be given,
Yes, your lordship.
as a token of gratitude to the land donation. But the sweeper, the person who was appointed as cleaner, he was appointed on a temporary basis. Right. So what will happen to that?
Now,
That's
your
what
lordship,
is coming to my mind.
coming to annexure C of my petition, of my affidavit, your lordship. Here, initially, when issue arose for the said post, your lordship, complaint was received by the department. So verification was done, your lordship. The 6th line, I may be allowed to read. Verification and identification of the landowners were done by the district administration. As per the report received from the district administration, the plot was donated by 2 brothers and one of the landowners, namely Sri Seile Tukotso, was appointed to the post of sweeper, your lordship. So basing on this,
He was so
Yes,
this
your
in a way this quota was full already.
yes, your lordship.
But that's what I'm saying, that his appointment was on a temporary, fixed pay basis, perhaps. I mean, he is not being regularized or what? Because as I understand, the appointment system, again, I'm repeating, and the appointment system pursuant to land donation is meant to be a regular appointment,
Yes,
right?
your lordship.
Yeah. As a token of gratitude.
No,
But
your lordship.
this person is, though appointed, but he is still in a fixed pay basis, right? So, will that constitute a appointment by way of, in a way, filling up the quota?
Yes, your lordship. That is
Am I being able to make clear what I'm trying to say? Okay. Though he was appointed as on a fixed pay basis rather than regular appointment. So will that constitute filling up the quota of land donation appointment? That's the thing. That is what is coming to my mind on issue. So anyway.
Now coming to challenging the constitution of the screening committee, your lordship. Here the petitioner, he voluntarily participated in the selection process, and when he was unsuccessful, he's challenging the constitution of this selection process, your lordship. So this cannot be done, your lordship, after having participated in the selection process and having failed.
Okay.
That's all, your lordship, my submission. That's all.
May it please so much.
R5, right? Respond.
Yes, actually respond number 5. In my humble understanding of the petition and the manner in which it has been drafted, my contention is that the petitioner has wrongly conflated the issue. One, regarding the appointment of the respondent number 5. Secondly, the claim for appointment on the basis of land ownership. Now, before I have only 3 main primary links of submission, but before I go to my submissions, allow me to take your lordship to the prayers, the release which have been sought by the petitioner at page 12 of the petition. Page 12. The petitioner has prayed for 3 prayers. One is for setting aside the sitting of the screening committee on the ground that the composition was not as
not
per
in
what has
terms
been
of
prescribed. Yes,
office memorandum.
of the OM. Secondly, the quashing of the appointment of the respondent number 5. And third is to direct the respondent authorities to consider his appointment on the basis of land ownership. Now, insofar as the prayer for setting aside of the committee is concerned, I have in my affidavit raised a preliminary objection to the effect that this petition is barred by the principles of estoppel, because it is settled law that once a petitioner or once a candidate having voluntarily participated in the selection committee or a process cannot again turn around and question the composition of the committee. Now, in the representation submitted by the petitioner right after the committee submitted its recommendation at page 35. Page 35 of the petition. The lordship will see page 35.
Yeah.
Yes. Here, the grievance of the petitioner was only with regard to the recommendation made by the committee. Nowhere has the petitioner raised any objection regarding the composition or the constitution of the committee, to the effect that the committee was not constituted as per the OM. Therefore, no protest was raised by the petitioner insofar as the committee, as the composition is concerned. Now, in this regard, may I just, for my own benefit, place one authority.
Okay.
Allow me to submit the authorities as I go along with my submissions.
Yeah.
I'm relying on 1995 3 SCC 486 at paragraph 9. Paragraph 9, I will not be reading the entire paragraph, but if your lordship may come down to Placitum C. Placitum C on the right side, it is now well. Page 493 of the report.
Yeah.
Paragraph 9.
It is now
Yes, it is now well settled that if a candidate takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or the selection committee was not properly constituted. And therefore, I'm submitting that this petition is barred by the principles of estoppel insofar as the challenge to the constitution of the committee is concerned. That is the first submission. Now, secondly, regarding the claims on the basis of land ownership.
Yes.
Initially, when this petition was filed, the petitioner had not disclosed that his uncle had donated, was appointed on the basis of, Now, in that view, I have in my affidavit in opposition raised an objection that he had suppressed material fact. He had effective knowledge that his uncle was already appointed. Now let's assume that the appointment was on the basis of land ownership. Assuming. In that view, I raised an objection that there was suppression of material fact because the petitioner knew that his uncle had donated, the two uncles had donated the land. One was appointed. This has been confirmed by the state's affidavit where the CMO has clearly stated that donation was made by the two uncles and appointment was done. Now, whether the nature of appointment, I'll allow me to come to that later, but this aspect of the matter has not been disclosed by the petitioner in his petition. And he has also not filed any reply to rebut this contention. Therefore, it is deemed to be accepted that he had knowledge that his uncle was donated and his uncle was appointed. And therefore, in that view of the matter, I'm also praying that the petition ought to be dismissed on the grounds of suppression of material fact. Now, regarding the appointment on the basis of land ownership, the policy which governs this is at page 39 of the petition. And since it's not very legible, they've also enclosed a type copy. The Lordship may come to page 41, the type copy.
Okay.
Here it says, this is the OM or the policy of the government governing the appointments as to how appointments are to be made on the basis of land ownership. Now, at paragraph 1A, it clearly states that, may I read out, Your Lordship? Yes.
What are the relevant parts?
Yes, it has been laid down so and so dated 26/7/2005 that no land shall be acquired free of cost and all land shall be acquired on payment of full compensation as determined by law. No further condition for employment in service or contractual work should be entertained. Therefore, this is the part. Therefore, in case any department has entered into any agreement with the landowners in deviation of the laid down policy on or after 26/7/2005, on or after 26/7/2005, such agreement shall be treated as null and void. The department concerned shall take necessary action according to nullify such agreement. 1B also. In case the department concerned is on the view that the agreement should not be declared null and void, it shall refer it with relevant details giving justification to the Department of Land Revenue for examination and advice in consultation with so and so, and thereafter submit the matter for consideration before the cabinet. Now, in this, the policy of the government is that after agreements which are made after 26 July 2005, it will be treated as null and void. And the reading is that the department has to enter into an agreement with the landowner. As Your Lordship had already earlier.
This notification is the grade 4 appointment notice.
Yes, this is the one.
26/7.
No.
This is the land ownership.
No. This present notification reiterates the earlier notification.
Yes.
Now, this is the standing point as of today. Now, in this, it says after 26/7/2005. Now, the agreement or the so-called agreement sought to be enforced by the petitioner, if Your Lordship may have a look, at page 16, type code.
Page
16 of the petition. Sir.
Okay.
Type copy, it says, we held a meeting on 20th July 2011. This is much post 2006 or 2005. Much after 2005. This is dated 20th July 2011. And also, this was a unilateral agreement or an intra-agreement between the landowners and the council. Now, the policy says the department has to enter into an agreement with the landowner. Therefore, the department or the concerned officials has to be a part. Now, in this case, if Your Lordship will have a photocopy at page 15 of this agreement sought to be relied on, the parties Your Lordship will see, the landowners on the left side.
Yes, so with the village council it was.
Yes, and the village council. Copy only was forwarded to the ADC. On that basis, they seek to enforce this. Now, therefore, the submission is that this agreement vis-a-vis the OM of the government on the appointment of on the basis of land ownership is not enforceable. It cannot be enforced, which the petition is trying to do in this instant petition. But again, the policy provides that if any, so the submission is that this agreement, which has been sought to be enforced by petition, is not enforceable, and therefore the claim on the basis of land ownership has to fail. But even assuming, because
okay,
yes, just an alternative submission. Now, nobody denies that the two uncles of the petitioner has
donated the land.
Now, the petitioner is not a descendant of the two uncles. Now, the policy, if Your Lordship will have a look again at the policy, page 42. Page 42, the type copy I'm referring to.
Two brothers donated?
Two brothers donated. Now that's admitted.
Son of one of them was appointed.
No, one of the brother was appointed.
One of the two
Petitioner-
brothers who donated
Yes,
was
one of
appointed
the
as Fisher. Now he is the
He's the real landowner. The petitioner is not a landowner nor a descendant. The policy refers to landowner or his descendant. which
he's a
was the-
nephew. He's a nephew.
Yes, he's a nephew. He's not a descendant in terms of this policy also. Therefore, he cannot claim.
Page 41.
Page 42. Just to take your lordship to the
Clarify.
word descendants. Who are to be the claimants? Which this paragraph has been, this clause has been relied upon by the state respondent. It is also clarified that it is not a policy of the government to provide employment to the landowner in perpetuity. The employment of landowner permitted by a verifiable and valid agreement is limited to the person first appointed as landowner in government service and does not entitle his descendants. So anybody who comes again in future for landowner, he has to be a descendant.
It's
You
one
have a
land.
locus.
No, it's not entitled as
Now
descendants.
this petitioner is
No,
not a
it's not. It's
descendant.
not in perpetuity. That's what.
Yes, it's not in perpetuity. In addition, he is not a descendant of it. Therefore, the claim on the for land ownership appointment, it has to fail on this ground as well. Now, assuming the
Okay.
yes, assuming the land was donated and the department has acknowledged such donation, and on that basis, the uncle was appointed. Now, the manner of appointment, yes, it says it's contingency and it's fixed. But the department has clearly acknowledged that the appointment was made on the basis of land ownership in the CMO's letter. Now, therefore, if any person is aggrieved, it is the appointee, the uncle, who has to seek for regularization, who has to seek for a post. He's the person with locus, not the petitioner. He's not aggrieved. The uncle is the landowner who donated. And if at all his appointment, he's aggrieved with his nature of appointment or the mode of appointment, being contingency, he has to seek for a vacant post and to regularize him in that post. Therefore, also, the petitioner has no locus to be agitating in the manner as have been raised in this petition. Now, the last point is that the pleaded case.
Okay.
The pleaded case in the entire petition is the screening committee is not properly constituted. And secondly, I have to be appointed on the basis of land ownership. That is the pleaded case of the petition. Nowhere has it been pleaded by the petitioner that I am at serial number 3 in the list of in the select list.
On the basis of
Therefore, I
marks.
ought to have been appointed. I ought to have been considered because the candidate number 1 was not selected. That is not a pleaded case. The only averment raised by the petitioner is that the candidate who was recommended was not appointed. Now, is it the place of the petitioner to raise such grievance? This candidate has to come before this court and raise the grievance. She or he is the aggrieved person. In the same manner, serial number 2, 3.
Okay.
Yes. May I take lordship to page 32, just to refer to the select list. The serial number 8, who was recommended by the screening committee, has not come before this court. The next in line is the one who scored 36, serial number 2.
He was appointed.
He's not before this court. Number 3 is the petitioner. He comes before this court, but not on the ground that I am at serial number 3. I have to be considered. His pleaded ground is that I have to be considered on the basis of land ownership. Number 4, the respondent for 5 is number 4, along with another person. Respondent number 5 is at serial number 5 in this document. And
why these two have not been appointed, ma'am?
Lordship,
Respondents.
therefore, my submission is
37, 5 and 36.
respondent authority has illegally appointed private respondent number 5, even though he was not in the merit list.
Okay. Anyway, so
now, therefore, none of the candidates who have, including the one who has been recommended, has not come before this court agitating their grievance to the effect that I have been recommended. Why should I not be appointed? In fact, it is the petitioner who is coming, espousing the cause of those candidates. The petitioner has no locus to do that in service jurisprudence. It is the person agreed to has to come and agitate her or his rights.
Okay.
Now, therefore, since it is not a pleaded case of the petitioner that he has to be considered because he has been placed at serial number 3, such submission, it has been advanced before the court, despite the absence of any pleadings to that effect, such submission be ignored. And therefore, in relation to that, the recommendation of screening committee is only recommended. Your Lordship knows very well the recommendation placed by the selection committee or the screening committee is recommendatory in nature, is not binding on the appointing authority. The appointing authority, for reason, is not placed before this court because the averment or the grounds has not been raised as to why this has been done. And therefore, in the absence of which the state does not have the material to assist your Lordship also, because the grounds have not been raised or pleaded. In that view of the matter, I'm also submitting the petitioner has no locus to maintain this petition. Now, that is my, in support of my submissions, allow me to just rely on certain authorities also.
Reply. Any reply?
Yes. Allow me to first rely on for the proposition that the petitioner is not a person aggrieved so far as this petition is concerned. I'm relying on 2013 4 SCC 465. 2013 4 SCC 465. Paragraph is 9.
2013, para 9.
Yes, paragraph is 9. I will not be reading on the entire paragraph, but I'm relying on it, but just for paucity of time. In the next page, page 476, allow me to just read out this line, page 476 of the report. Just below placetum B, the existence of such right, continuation. Yes. But the existence of such right is a condition precedent for invoking the writ jurisdiction of the courts. It is implicit in the exercise of such extraordinary jurisdiction that the relief prayed for must be one to enforce a legal right. And in my humble submission, the petitioner does not have any legal right, no right to enforce in this petition. In fact, the existence of such right is the foundation of the exercise of the said jurisdiction of the court. The legal right that can be enforced must ordinarily be the right of the appellant himself, not some others who have been recommended, serial number 234. Now, regarding the pleadings, I will not be reading on the pleadings, but the pleaded case is that the petitioner has to be appointed on the basis of land ownership, not on the ground that I'm serial number 3 in the select list, and therefore I have to be recommended. Therefore, in that view, allow me to just rely on two authorities also. One is 2024 20 SCC 23, page 23. 2024 20 SCC page 23. Paragraph is 52. 52, yes. It's a short paragraph, allow me to read. Based on the effort, page 48. Lordship has, yes, page 48, paragraph 52. Based on the aforesaid authorities, we hold that while deciding a writ petition on the basis of affidavits, the writ court's inquiry ought to be restricted to the case pleaded by the parties and the evidence that they have placed on record as part of the writ petition or the counter or reply affidavit, as the case may be. Findings of the court have to be based on the pleadings and the evidence produced before it by the parties. It is well-nigh impermissible for the writ court to conjecture and surmise and make out the third case not pleaded by the parties based on arguments advanced in the course of hearing. There is one, and the other authority is 1953 1 SCC 456. This was one of the authorities which laid the jurisprudence insofar as pleadings in writ petitions is concerned. Paragraph is 38. Paragraph 38, page 469 of the report. Paragraph 38. Just a short 4 lines. we are unable to uphold the view taken by the High Court on this point. It is well settled that the decision of a case cannot be based on grounds outside the pleadings of the parties, and it is a case pleaded that has to be found. And therefore, in the essence, insofar as the pleadings in this writ petition is concerned, it is confined to the challenge, to the composition of the selection committee. This is already barred by the principles of estoppels. Secondly, the claiming for appointment of land ownership, the agreement sought to be enforced is not enforceable in view of the grounds, which I have submitted. Therefore, my humble submission is that the petition ought to be dismissed. I'm grateful, Lordship.
Lordship, I will reply just one, two. With regard to this submission made by the state that in the agreement, they were not a party. However, Lordship, if we see the agreement, page 15, Annexure A, the Chief Medical Officer of Dimapur, Nagaland, he has acknowledged his seal in the agreement. So he or she is a part and parcel of the department.
Where has he given the seal? Copy to CMO, so and so, so and so.
And
Receipt copy.
yes, Lord.
Receipt copy.
Lordship. And moreover, in their affidavit, they've clearly stated in paragraph 5. If at all this agreement is considered as null and void, then one of my uncle should not have been appointed as sweeper on contingency basis. But they are contradicting their own statement. At one stand, they are stating that this agreement is without their knowledge and they are not a party. However, they are a party because they have acknowledged it, the CMO, and the CMO is a part and parcel of the department. And on the other hand, they have, in their affidavit, they have clearly stated that in lieu of the land and the agreement, they have appointed the petitioner, one of the petitioner uncle, on sweeper on contingency basis. And with regard to respondent number 5, Lordship, with regard to the office memorandum, page 39, Annexure L. Therefore, in any case, any department has entered into any agreement, para 2, with the landowner in deviation of the late policy on or after 2005. Such agreements shall be treated as null and void. The department concerned shall take necessary action according to nullify such agreement. And in para 3, in case the department concerned is of the view the agreement should not be declared null and void, it shall refer it with relevant details giving justification to the Department of Land Revenue for examination and advice in consultation with PNR and Justice and Law Department, and thereafter submit the matter for consideration and decision of the cabinet. So there's an alternative, and no documents has been placed before this honorable court by the state. However, with regard to the agreement, the department has appointed it, my uncle. If at all, the agreement is considered as null and void, as per this OM, the state ought not to have appointed my uncle as sweeper on contingency basis. So this point has to be noted. So, and another point, Lordship, with regard to suppression of fakes. Yes, Lordship, it's in my knowledge that the department has appointed my uncle, and I have not stated in my petition. It's in my knowledge. However, there are 2 brothers. One was not appointed. So one of my uncle, you claim the benefit which I am about to claim from the department. So I'm claiming appointment on land owner basis of one of the other brother who has not availed any benefit from department. And that is very clear from the department letter as well in Government State Affidavit, page 12 Annexure C. Page 12 Annexure C. Yes, a screening committee, third para, a screening committee was set up after receiving the verification of the landowner applicants. So it's in their knowledge. They've received an application. That is my application from the district administration. The applicant who scored the highest during the interview held on so-and-so was put up for recommendation only by the screening committee. It is also to be noted that the complainant is third in merit list. So I'm the complainant. But if the department feels that it is duly just unjustified, the screening committee leave it to the department for appropriate compensation of the complainant, who is also rightly the nephew of the landowner. So in lieu of my land, the department also stating that if post was not availed to me on landowner, to one of my uncle, then compensation be paid to the complainant. But till that, no compensation has been paid to me. So coming before this honorable court for appointment on land ownership, is a rightful claim of the petitioner.
Okay.
Lordship, may I be allowed to submit just one proposition, just taking cue from my learned friend's submission. Now, there's an alternative in the OM, no doubt. But whether it has been honored by the state government, those are not review of this petition. Now, the petitioner or their uncle or his uncle, they are at liberty to pursue those matters before the appropriate forum. They can pursue it that to the effect that the department has to honor this agreement or pay us compensation. But that's not the case insofar as this petition is concerned. Therefore, without interfering with the respondent, liberty can be granted to the petitioner or his uncle to pursue appointment or compensation as the case may be. That is my
One point to be noted is that the private respondent was appointed in violation of the OM, and moreover, the private respondent, he was not in the merit list, and his name was never recommended by the selection board, but he was appointed with favoritism and nepotism.
Okay, Alexander,
No.
respect all submissions that you made. Okay. Lord Counsel for the petition. Government Advocate, Madam. Yes, Inawali. For the respond number 1, 2, 4. You're Mr. Learned Counsel for the respond number 5. Private respondent arguments are addressed and concluded. Judgment is resolved. I'll deliver from there. No?
No.
Yes.
I'm going now.
Yes.
This is my 2 weeks is over today. Hope to see you next time. So staple it. Yes. This one.
Oblige.
Molo. Molo Jin.